I think that's fine, but I just wanted to be clear that under the current system, at least, recognizing that, there could be changes in the future, it would just mean that the application goes nowhere.
We share those concerns for PDS. I mean, that we really have to be robust in making sure that individuals aren't sort of falsely lulled into a sense that this is sufficient for consideration.
Right, and ultimately, I think that is something that we have taken into consideration. We want to be able to have that conversation with the White House in the long run, and we have intentions of scheduling that for the board. We just wanted to be able to have a regulation in place for this application. And I think what Vanessa highlighted is that there is a educational component about what the board actually is doing, that it is a letter of recommendation, not a grant for clemency. Any additional concerns?
I have a question.
Sure.
Does either one decision supersede the other? So, for instance, if you were to file for a DOJ pardon and then file for the letter of recommendation from the Clemency Board, would either decision in any case supersede the other?
So, Mr. Blow, we will certainly take questions from the public. We're currently just taking questions from the board, but if you could hold that question and then we will address it at the public comment section.
Is this comments on the entirety of the document?
Correct.
Are we going in order? Okay. And I'm sorry that my video is not working.
No worries.
There's just not even an option for it for some reason on my screen. On page 2, in the sort of the preamble, the word offender is used, and we'd requested that not be used at all. And it's not used anywhere else in the regulations, but it's used in the preamble or the explanation. And so it's on page 2. So that should be substituted out. And we made that comment before. And appreciate that language is not used throughout this, the actual regs. So it could just be individuals convicted of DC code offenses, just a language that is not that is not offender.
Sure.
And it's twice, I think, in the same paragraph.
I support that and have a parallel thought. There are a few times throughout that it refers to convicted of district offenses, and I would suggest for clarity it be convicted of DC code offenses, to just clarify that we're talking about that. I don't think it could necessarily be inadvertently interpreted to apply to federal court charges in the district, but just to ensure that we're being specific, individuals convicted of DC code offenses throughout.
Okay. Okay. Any other concerns? All right, if no concerns, I'll pick back up from where we were. With respect to the second half of paragraph 7.4.2, it states that applications to the board are not applications for pardon or commutations. Applications submitted to the board are for a letter of recommendation from the district recommending a pardon or commutation on behalf of an applicant to the President of the United States. Does the board have any questions or concerns? Okay. With respect to 704.3, it states the board may issue a letter of recommendation for eligible individuals who've been convicted of DC code offenses. So I'll add code here. A DC code offense, letters of recommendation for clemency are issued in sole discretion of the board and are sent to the President of the United States with a copy to the DOJ pardon for consideration in the clemency review process. The letter shall be sent through the established processes for the district government to communicate with the federal government. Again, this is going back to the public comments to send letters of recommendation directly to the president. Any questions or concerns from the board? Next on review of applications under B, as he indicated when we sent out the regulations, we had additional comments that came through the IQ process. We also sent the regulations, the edits that were sent out to you back to OAG, and we had some small changes here that I've noted in the comments, but the paragraph reads, if an application is missing required or otherwise necessary information or documentation, OGC may promptly send a letter to the applicant requesting that information or documentation. Initially, it said the board shall, and that change was suggested to say OGC may, partly because we believe it would be an administrative backlog for the board to have to reconvene every time information on an application is missing. Let's say an applicant fails to provide a signed release, or an applicant fails to add their social security number to an application. We would not need the board to vote to send the applicant notice that they are missing information on their application, but that OGC, as the staff director, can move processes along to get that information and then present a complete application to the board for consideration. Any questions or concerns?
This is Emily. I did have a question related to that, Christina. I just wanted it to be clear, as I understood what you're saying, it will be staff at OJC who's going to be tasked with actually trying to obtain the outstanding information and helping to gather everything we need to consider the application. Is that right?
Correct.
Wonderful. Thank you.
This is not necessarily within my expertise, and I might defer to Katja on this, but if an applicant is represented, would the same procedures apply, or would it be a different procedure? Would it go directly to the applicant or to their attorney, recognizing there could be non-attorneys assisting them as well?
That is correct. The application does consider that and ask the applicant how they would like us to interact with them or their representative. So the application does consider that, but that does not need to be stated in the regs. It's in the application.
Thanks.
Sure. Any additional questions? Okay. The next sentence states, if OGC does not hear from the applicant within 3 months after sending a letter requesting the additional information or documentation, OGC will send a second letter requesting that information or documentation. So OGC will provide 2 notices. This was suggested by one of the public comments that 1 notice was not enough. For missing documentation, we think that's reasonable given the population we'll be serving. It might serve to their benefit to be able to provide more than 1 notice over a 6-month period. And it states that if the applicant fails to respond to the second letter within 3 months, the board may deem the application complete and close the application. Any questions or concerns? I should state that a closed application, which is also another public comment, a definition for a closed application we will later cover further down, does not mean a denial of an application. It's just an administrative closure.
Hi, it's Felisa. Christine, I had a question.
Sure.
Maybe I should raise it later, but I was wondering, kind of like with the previous discussion, would an application be considered closed if a applicant did not have a application pending with the DOJ, or we would conduct our independent business, and then what the applicant decides to do at the DOJ is separate. So I guess I'm concerned about limbo of application, like if they haven't begun application with the DOJ, what would the board do with their letter of recommendation?
Right. So some of the public comments was that we don't require there be a DOJ application before they come apply to us. So the process is currently they can apply for a letter of recommendation from the board, and that letter of recommendation will be sent to the president and the DOJ. We will encourage our applicants to apply for clemency if they're eligible with the DOJ. And what they can do is take that letter of recommendation and supplement it into their application. But if the application form asks if an applicant has a pending DOJ application, and if they do, we would send our letter of recommendation to the DOJ as well, so it can be added to their application.
Okay. All right. Thank you.
Sure. And to answer your first question, no, an application will not be closed if they do not have a DOJ application. That is not one of the requirements for closure. A DOJ application is not a requirement for a clemency board letter of recommendation.
Hey, Christina, it's Sonia. I had a question going back to the second sentence with the second letter. I know that was in response to like the reality that DC residents are transferred to different facilities and BOP. And I'm wondering, is there a requirement that we look up if the person has been transferred? Because just sending a second letter to the same address, is that going to accomplish the issue of whether, if the person's been transferred, what's a second letter to the same address going to do?
Right, right. And we're certainly aware of all of that, and we'll do our absolute best when we do send those notices to confirm their receipt and arrival at the right location.
Okay.
Okay. I will move forward if there are no other questions. With respect to C, it states if an applicant is not eligible for a letter of recommendation under the Clemency Act, the board shall send a letter to the applicant informing them of their ineligibility and providing information of their ineligibility and provide information. This should say provide information on how to reapply. If they do become eligible, the application will then be closed. So the statute currently has some requirements that an app for a person to be eligible for a letter of recommendation. So that what that is referring to. So once we do send a letter of recommendation, we just wanted to clarify that their application would be closed because they've been found ineligible. Okay. No questions and concerns. I'll move to D, which states that the board may authorize OGC to send notices to an applicant if, and this goes back to what we initially stated, an application is incomplete or complete, an application is being closed or deferred, or the applicant is ineligible according to the Clemency Act. Going back to what deferral means, an application will be deferred when it's missing information and we are waiting to retrieve that information from an applicant. So that's what deferral means. Complete means that it's received a complete form with signed releases and supporting documentation. Incomplete obviously is pretty self-explanatory, that we don't have the necessary documents to process the application, and ineligibility is based on the Clemency Act. And what this states is that OGC will provide those notices and the board would authorize OGC to do that. Any questions or concerns? Okay. E states if the application is complete, the applicant is deemed eligible, the board shall decide within 6 months after receiving a complete application whether to recommend the applicant for clemency to the President of the United States in accordance with the Clemency Act. Any questions or concerns?
Is that to be understood as sort of jurisdictional, that if we fail to act within 6 months, that we are therefore prohibited from acting in the 7th month?
No, it's just it's required by the statute, and I believe I believe it's just to make sure that the board moves these applications, that they're not being held for a long time, that we actually do act once we have all the necessary information and an application is complete, that we issue a decision whether or not to write a letter of recommendation or not within 6 months.
Understand that, but I don't want anyone to think that means we can't act if we miss the 6-month deadline, which may happen.
And that's certainly within our control. At that point, we have to make a deferral if the board feels it doesn't have the necessary information. Again, the 6-month time clock only starts running at once an application is complete. And once the board sends a notice to an applicant, then an application is complete. It has 6 months to issue a decision. That is in the statute, and we have to be compliant with the statute unless there's a legislative fix.
Okay, thank you.
Okay, any other questions? All right. F states the board may deem an application incomplete and defer it, thereby extending the 6-month decision period if the board lacks sufficient information to form a recommendation, such as when a request for background information is delayed or when a hearing could not be scheduled timely for reasons outside the board's control. As you can see in the comment bubble, after the board's control, the regs that we sent out said, or for other good cause. We think that it was duplicative because if something couldn't be scheduled or it was delayed for reasons outside the board's control, that is for good cause. So OAG suggested removing that language. Okay. If there are no questions or concerns, I'll move to G. G goes into a bit of an explanation of what is a closed, complete, deferred, denied, granted application. So it states that an application to the board may be closed, complete, deferred, denied, or granted as follows. The board may close an application if it deems the application is incomplete because the application is missing necessary supporting documents that the applicant has failed to provide within 6 months after applying as required by section 705.1B, which goes into those two notices. Or it deems that the applicant is ineligible based on the eligibility criteria set forth under the Clemency Act. The closure of an application is not a denial of the application. An applicant whose application has been closed may subsequently reapply if the applicant provides the documents necessary or to complete the application or has become eligible. Any questions and concerns about the closure of an application? Okay. 2 states an application is complete if the application form and releases required by 704.2 are fully filled out by the applicant and the application contains all the necessary information and documentation necessary for the board to consider when deciding whether to issue a letter of recommendation for clemency. The relevant information and documentation the board may need to evaluate an application may include information or documentation collected from law enforcement agencies, the courts, and the applicant.
There's 2 necessaries in that thing. I think we only need 1.
Where is that? Oh,
I'd suggest we take out the first necessary.
oh, okay.
Or no, that's fine. Either one's fine.
Either one? Okay.
Are the references here to law enforcement agencies, is that mostly BOP and CSOSA that you're talking about?
Correct.
So in this edition, this is Felicia, there's no mention of kind of OGC, Office of General Counsel, kind of being the agency that designates whether a application is complete. And from the reading of the, I guess I'm concerned about like the 6 month, I guess, tolling issue that we have with, I guess when we have to count when the 6 months in which the board has to act begins. And it seems like the Office of General Counsel is the designee of when an application is complete, but there's no mention in here that OGC is kind of, seems like in charge of that. So am I reading the regs wrong, or should some additional language be added?
No, actually, the completion of an application is the board's determination. And so when OGC will collect that information and it's the board that decides that, yes, this application is complete, at which point that's when a notice will be sent to an applicant that their application is complete. So it's the board that decides that. We will collect the information for the board and present it to the board. And at which point, if the board decides it needs additional information, we can retrieve that, seek it from an applicant or seek it from law enforcement agencies. At the point which a notice of completion is sent out to an applicant, that 6 month clock begins. At that point, we're stating that we have all the information we need to evaluate an application and issue a decision.
Thank you for that clarification.
Sure. Okay. Number 3 states that an application is deferred if the application is kept open because the board has determined that the applicant will need more time to provide supporting documentation, or a hearing was needed, but for logistical or substantive reasons, the hearing was not able to be scheduled within the 6-month time frame to process an application. Part of this is just giving the board more flexibility because we understand that applicants may have difficulty to attend a hearing, the logistics of coordinating with BOP and video conferencing, tracking down applicants, hence why we would want to elect to utilize a deferral option to not start that 6-month time clock. Number 4 states that an application is denied if the board, after review, has decided not to provide a letter of recommendation for the clemency to the applicant. Denied applications may reapply for a letter of recommendation from the board after 2 years after receiving a denial. Any questions? Okay. And fifth,
I would take out the first after in that. Denied applicants may reapply for a letter of recommendation from the board 2 years after receiving a denial. The first after can go. And I think it's decided not to.
after the board has decided not to.
Yeah. Okay.
And that subsection 5, this is a drafting question, so I'll really defer to you on it, but do you think it might be helpful to clarify that this does not necessarily mean that they will be granted pardon or commutation? I just kind of want to eliminate confusion on behalf of the people applying. I know that we've kind of spelled that out elsewhere, but it kind of says an application is granted, which I'm worried could kind of engender confusion about what that means, even though it is in other parts of the regs.
So an application is granted if the board, after review,
it could be phrased better than this, but you know, at this point, it will be forwarded to the appropriate people for review of clemency. That might not be a very good way to draft it, but I just wanted to clarify once again that, you know, just so people's, I think, expectations are clear.
let me know if this suffices. An application is granted if the board, after review, decides to provide a letter recommending the applicant for clemency. A granted application is not a grant for a pardon or commutation. It is a grant only for a letter of recommendation from the board.
That looks good to me. Thanks for the clarification.
Sure. Okay. 705 705.4 states, to the extent consistent with the Clemency Act and other district law, the board may authorize applications for review according to the priorities or initiatives outlined above, or in the order in which applications are filed or completed, or some combination of both. Or may prioritize applications, I believe this should be, or may prioritize applications for a particular type if it so chooses. The board may authorize OGC to prioritize applications under any criteria identified above. So this flexibility of deciding which application to prioritize was added. I'll give you a scenario where this may be very important. Let's say terminal an applicant that is terminally ill and has been given 6 months to live. And that is one of the priority groups according to the Clemency Act. The board may choose to prioritize those applications over applications of a person who is elderly, which because partly for the nature of the fact that they only have 6 months to live. And so this just gives the board's flexibility based on the applications we have to prioritize which ones need to be considered ahead of others. Any questions or concerns? Okay. 705.5 states, the board need not score or award or deduct points for any particular element of an application. The board may come to different determinations on applications that by some measure appear similar. The board may establish procedures for engaging pro bono counsel to review or advise on applications, but may not delegate final determinations, except when delegating that authority to OGC to close applications that are incomplete or from persons who are ineligible for a pardon or commutation. I would suggest one change here, and instead of saying ineligible for a pardon or commutation, I would state ineligible for a letter of recommendation from the board.
That's fine.
And can you also just discuss a little more how the pro bono counsel aspect will work and kind of what confidentiality measures they'd have or how they would otherwise interact?
Sure. So part of it is just the idea that this might be a big lift for the board to conduct, and that applicants, we may want to recruit pro bono counsel to assist in the compilation and application retrieval of information. And what initially, when we do receive assistance from pro bono counsel, if needed, we would be able to make sure that confidentiality is maintained. Okay. No additional questions? All right, 705.6 that states, should a hearing be held, it will be held in closed session and applicants will be allowed to access their own attorney or non-attorney representative in accordance with the Clemency Act. Notice of each hearing shall be given at least 90 days before the hearing, if feasible, and will be sent to the applicant and the applicant's attorney or non-attorney representative, if any. Each notice of the hearing shall contain the date, time, and location of the hearing, including for hearings conducted by video or teleconference, and process of an applicant to inform the board of a need to reschedule the hearing.
I know I've mentioned before kind of thinking about kind of ways to involve victims in this process and how they would be notified potentially. I believe the regs are silent on this. That might be appropriate, but I was just kind of wondering what we plan to do with respect to victims of the cases that are being considered for clemency and how they might be notified and by who.
That is a great question, and we certainly want to involve victims who are affected by applications we receive, and we can certainly add in information that would also be sent to the victims involved in this case. If we're able to retrieve their information, it's totally up to the board if they would like to add that.
I don't know that we necessarily want to have, I don't know, I'm conflicted. I think it merits discussion. I don't know that we just want to kind of send a letter, by the way, this is happening. I don't, I think it might kind of be more depend on the case and kind of depend on the circumstances of that and to how it's approached. I just think that it's something, and maybe it's something that isn't in the regs and something's just considered, but I just kind of wanted us to be mindful of the approach that we're taking and, kind of how that outreach happens in a kind of trauma-informed way.
Sure, sure. Any other comments from board members about how we want to tackle that?
It's a really great point. Thank you for making it, Alana. Christina, I cannot remember. I have not, elsewhere in these regs, does it say anything else about communication with the victims? I thought we had something about it in our, on the board rules as well, but I'm just not recalling if we've addressed this elsewhere.
No, we have not addressed it elsewhere. We've kind of kept the hearings very general, just that what would be in notice of those hearings. But, certainly providing notice to victims is worth thinking about and how that can be done. It can be added into our internal processes. It can be added to the regs, but it's definitely something that the board can decide to vote on.
Yes, I remember, this is Felice. I remember discussions before we had the regs, when we had the regs in draft form, that we would probably leave like internal kind of hearing procedures, kind of more up to maybe a procedural hearing manual, as opposed to putting something about how we would conduct the hearings in the regs. So that gives the board leeway to kind of create its own kind of hearing procedural manual, but that's what I remember being discussed.
Sure, certainly, and that is it. You are correct. The internal procedures are another place where that can be put in. But if the board intends to put this in the regs, we can put it in the regs, or we can put it on the internal procedures. It's the board's decision.
Is there anything in the law that requires us to notify the victim of the hearing?
Not in the statute, no.
Okay.
Yeah, I had a question. Can I?
Mr. Stewart, yes, certainly. You can certainly ask questions. We're just taking questions from the board right now,
Okay.
and then we will open to the public.
Okay.
Thank you.
I am comfortable, I think, with it being as Felisa recommended or suggested, it being in, because I think she's right. There's going to be a whole lot of detail we need to include about the hearings, who's entitled to be there, et cetera, and that maybe that's the right place to do it.
Okay. All right. If no concerns from the board, we can certainly work on building that process.
That's fine. And I do think that kind of not having it in the regs kind of allows a more tailored approach to address it in a more appropriate way. I just wanted to raise it as an issue for us to further consider.
Great. Thank you. Okay. Next, under 705.7, it's just adding a couple of definitions here, is that instead of stating that the board may, it would say that the board shall grant, defer, or deny applications for a letter of recommendation by majority vote of the members present and voting. A board member who in their professional or personal capacity has previous involvement with an applicant's case must recuse themselves from voting on the application, but may discuss cases or provide information known to them consistent with their office's policies, conflicts of interest rules, and any applicable ethical or professional standards. The ethical and professional standards was added instead of bar association to include professions that are not just attorneys, because we understand that not everybody on the board will be an attorney.
Thank you very much.
Any questions or concerns? Okay. 705.8 states that when the board votes to recommend an application to the President of the United States, the board shall send the application along with a finalized letter describing why the board recommended the person for clemency and supporting documentations to the President of the United States and DOJ pardon through the Mayor's Correspondence Unit or a similar process. If certain supporting documentation cannot be further transmitted consistent with obligations to protect confidentiality, the board may make arrangements for in-camera viewing of such documentation where possible legally and logistically. The board may delegate any letter writing to OGC, and the board chairperson may edit or sign any letter without further obtaining a majority vote on the letter itself. Any questions or concerns? Okay. 705.10 states that applicants may reapply to the board for a letter of recommendation starting 2 years after the date of any denial from a previous application. That's just reaffirming the ability to reapply even after receiving a denial. And that reapplication is possible when the applicant has retrieved the information, supporting information that they need, or maybe the applicant becomes eligible. And by eligibility, if we look at the Clemency Act, there's some waiting periods, like an applicant has to wait 5 years and so forth. That's what we mean by become eligible.
This may have been addressed elsewhere. If a person has multiple convictions for which they're seeking relief, do they have to file those all together, or can they be separate? And if so, kind of how do the waiting periods vary if they filed them successively?
Right, and that's something we'd have to evaluate by each application. It's totally up to the applicant what they're seeking a letter of recommendation for. If they're seeking multiple charges, then we would have to evaluate it according to each charge. But if it's just one, we would just evaluate it by one.
So if the board had multiple different ones pending, you could kind of combine them and consider them together. Is that right? I'm just kind of thinking if there was perhaps one victim who was the victim of several different convictions, and a way to kind of streamline this experience for them.
So the application form asks what they're seeking an a letter of recommendation for, like what charges specifically they're seeking a letter of recommendation for if there are multiple ones. So we would only technically have one application per applicant. We would not have multiple applications.
So it's by the applicant, not by the conviction, essentially. That's what you're saying.
Correct.
Got it. Okay, thanks. That's helpful.
Okay. Next, we'll turn to the section on confidentiality. In 706.1, some few minor changes here. It states that proceedings of the board shall be subject to the Open Meetings Act, which we've covered already, except that board proceedings shall be held in closed sessions when permitted by subsection 703.7. And that's where we stated that there might be opportunities when the board will need to close its proceedings, confidentiality reasons. Okay. So this is with respect to reporting requirements. We're statutorily required to provide some reporting requirements. We originally stated that August 30th of each year would be the date for reporting requirements. A public comment came in that it should be consistent with the fiscal year, which is September 30th. But we added 45 days from September 30th to be able to give the board time to gather that information for the fiscal year ahead. And release that information. So this edit was made in accordance with a public comment to marry up the reporting requirements with the fiscal schedule. Any questions or concerns? So 708.1B states that we will provide reporting on the number of applications the board received, including the number that were complete at submission and the number that upon further submissions became complete. So it goes back to what the fact that the board now is, we tried to create a separation between what is a complete application and just an application form. So we'll provide reporting requirements on when an application that's given to us is fully complete, if possible. That would be an applicant who's really good at submitting applications to the board, and applications that we had to reach out to the applicant, law enforcement agencies, in order to make an application complete. So that's the two differences. Any questions with respect to B? Okay. F states the reporting requirements that we would provide the number of applications for a letter of recommendation that were closed by the board. And this is a comment that we just received, that to add DC code offenses here instead of district offenses. And with respect to administration, it states here, as OGC serves as the staff support for the board, 709.2 states the mayor's general counsel or his or her designee within the office of general counsel shall serve as the staff director of the board. It was just to clarify that it would be the designee of the general counsel. So for instance, the general counsel is Betsy Cavendish, and I would be a designee of the general counsel. Any questions or concerns? Okay. 709.3 states that OGC may rely on other agencies for assistance in carrying out its duties, including the provision of computer technical assistance, inclusion of notice in the DC Register, mayoral correspondence transmitting board recommendations to the President of the United States, and DOJ pardon and archiving or destruction of records. Any questions or concerns? Nearing the end, we've reached the definition section. One of the public comments we received was that we originally had the acronym for DOJ pardon as DOJ OPA, and it caused a lot of confusion because there is also a DOJ Office of Public Affairs, and so we just changed the DOJ acronym to DOJ pardon for clarity. The definition of a hearing, we just added that hearings would be closed board sessions for confidentiality reasons. And that's it. I think we have reached the end of the board regulations. Any other questions or concerns with respect to the board?
A very small one. I know at the end it said district offense, and I know I discussed DC code offense, and I wasn't sure if there was needed to be matching throughout.
Tell me where you saw that, sorry.
In the definitions, it says district offense, and I know I'd suggested changing it to DC code.
Sure.
Conviction. I forget the exact wording.
DC code offense.
Marrying them up.
Sure.
Thank you for that. Are there any other comments from the board? Any other additions that the board members of the board would like to make?
I just want to add one additional clarity here is DC code offense would limit it to strictly the DC code, but not to regulations. I think there's a clarity here is that the reason why it was under DC offense is a violation of the DC law or regulation. So I think it would make sense to leave it as a district offense.
That's fine, and perhaps it can just kind of clarify just it's the DC violation. I'm open to options on this. I just thought it would be a useful clarification at some point, but I don't have strong preferences for a certain language versus another one.
Okay, my recommendation would be to keep it as district offense to include regulations as well. If the board has any issues with that, I will revert it back. Okay.
Okay, I'm just going to ask one more time. Is there any other comments by board members? Okay, with that, I'd like to ask if there are public comments, and Christine, I'll rely on you to help us understand who's asking, and if people would state who they are, and if they're representing an organization, who that is.
Sure, if I will, if you could give me a moment to view my screen again.
Yeah, we can still see your screen.
Okay, great. And I can call, and I'm happy to share my screen one more time for public comments.
So are there comments from the public? I know two people raised their hand during the presentation.
Yes, so I'm happy to go down the list. First up on the list is Professor Ross.
Can you hear me now?
Yes, we can
Okay,
hear you,
thank
Professor
you.
Ross.
Well, first of all, thank you for this hard work. It really was incredible, all the changes. And I want to say really on behalf of the whole reentry clinic that you really looked at what we talked about and went back to the original statute. And I just think it's a huge improvement. So I really have two questions, and one of them is just when will the applications be ready? Because that might also inform some of the other question as well. When I read this the first time, I was a little unclear about when you talk about missing documents versus the idea of that the person supplies the releases. And so if you can just, something like the application might want, I imagine they would want to look at like the last 3 years of the person. If somebody's in custody now, what are the last 3 years of their disciplinary record? Something like that. So would that be something that would count as the person does a release on all of the board, BOP records, and then the application isn't really complete until you actually get those records, but they've filed the release. And so that would fall into that area where, if you have to wait 9 months for BOP to send them to you, it's open those 9 months. So that's my main question. And also, if you have an idea of like what are going to be the required documents that you're thinking that you want the individuals to give you, whether we're talking about pardon might be very different from talking about the other, but you probably have, this is all very abstract. So if you could just give us an idea of like what are the documents that you're expecting the person themselves to get versus the documents that you're thinking they'll just do a release and it'll be pretty much across the board, you'll be getting them.
Thank you, Professor Ross. So the answer to the first question is when will the applications be ready? That is on the agenda for today to us to review the application process today. As to the missing documents versus the release or what are the required documents, I'm going to let one of my colleagues handle that.
I was
Sure.
thinking Miss Sacco also might have an idea when she wrote this.
I bet she does.
Professor Ross, yes, to answer your question, the application would remain open until we receive the documents from that release. So hence why we wrote it this way, because we understand that receiving documents from DOJ, from CSOSA, from BOP could take time, and so it's physically impossible to do it within 6 months. Hence why the 6-month timeline doesn't begin running until an application is complete, and that includes all supporting documentation.
Brilliant.
And with respect to what those documents are, you are correct. It is very abstract, but we have a list currently, and when we review the application, that list will be there. And of course, if the board decides it needs additional documentation that should be on that list, when we review that application, we'll discuss that then.
And what were you envisioning for what the person themselves? What are the missing documents you're imagining that they're not giving?
We really would just like a completed form to be able to reach them, a signed form, signed releases. So we're not created with an administrative backlog from BOP where they state like, oh, this release was not properly signed. We would love it is, for instance, if an applicant already has their criminal records with respect to that conviction, that we could also get that copy from them and marry it up with what we receive from law enforcement agencies. So along those lines. Sure.
Moving on.
Any other questions, Professor Ross? Okay. Patrick, if you would like, I'd call the next person on the list.
Yes, please.
Okay. And next on the list is Professor Moyd.
Thank you. And it's always a pleasure to follow my colleague. I have three questions or points that I'd like to make. One is regarding 705.1B. And that's where you talk about the 3 months and additional 3 months to get documents and make contact with the applicant. I know that a concern was raised earlier about individuals being transferred from place to place, and sometimes we just have no idea where our clients might be in BOP. And so I wonder if that section should include some language that might state something like diligent efforts have been made to locate the individual through BOP information and other resources. I just wonder if, it should state affirmatively that all efforts to locate the individual have been exhausted before the time period expires. That's one point. The second point has to do with 705.1G, with closing the application. My concern is that since OGC is playing a role in supporting or helping the individual or the board to get documents, whether that section should include some language that the application is not closed until after the Office of General Counsel has confirmed that they have exhausted all avenues to obtain the documents. And then my final point is a small one, 705.8. I didn't see anything that indicated that, or maybe it's under 705.9. I didn't see anything that said that once the letter of recommendation is done, if the board decides to submit one, that a copy actually goes to the applicant. I didn't see that unless I missed that. And those are the only points I have.
Thank you, Professor. I appreciate them. Christina, are you prepared to respond?
Thank you, Professor Moyd. I'm happy to share my screen one more time to address your concerns. Let me know if you can see my screen.
Yes.
Okay, I will start from the bottom and work up.
Okay.
So with respect to 7.5.8, you asked whether or not the applicant will receive final notice, and that is in 7.5.9, applicant shall be provided notice of final decisions by the board and the mayor on whether to issue or not to issue a letter of recommendation for clemency subject to any administrative or judicial review. These decisions are expressly committed to the discretion of the board and the mayor. Further, the basis and conclusions for these decisions are also not subject to any administrative or judicial review.
Right, but will the person actually receive a copy of the recommendation? I know they will receive notice of the decision,
Right.
but receiving a copy of the actual letter that was written on their behalf.
Yes, they will. They
Okay.
will. Okay. I believe your next question was with regards to 705.1G.
Yes.
Okay. And here you stated with respect to closure that it's OGC that determines when to close an application, and that is not correct. That is the board's decision on when to close an application. It's not the board's decision. So I can certainly say that an application is not closed unless it's missing the information within that those two notices that we do send out. So it is not an OGC decision. It is actually a board decision.
Right, but I wonder, since OGC is playing a role in obtaining the documents, whether it should state that OGC has made a diligent effort or done everything that it can to obtain the documents.
Right. And that's certainly under 705.1, which goes into those notices that you mentioned. So I'm happy to add in a diligent effort on there. Initially, part of the reason why a change was added here was because initially we were just providing one notice. So we're now extending two notices. And so what it states is that if OGC does not hear from the applicant within 3 months after sending the letter requesting the additional information, OGC will send a second letter requesting that information and documentation. If the applicant fails to respond to the second letter within 3 months, the board may deem the application incomplete and close the application. We can certainly put something along the lines here if diligent efforts has been made to reach the applicant.
Yes.
If the board,
I think, yes.
okay. If the board has no concerns with that, I can certainly add that in.
Any concerns on the part of the board? Hearing none, I think we're good.
Okay,
Thank you.
sure.
Thank you, Professor.
This is Betsy. I'm sorry, I'm not in a super private place, but I'm a little worried about kind of vague words like diligence. I think if we make 2 tries, that's good. And I'm just worried that there'll be an effort to say we weren't diligent enough because we didn't repeatedly call various BOP facilities or something like that. I think diligence has too much vagueness, but you guys can be assured that we're going to try hard to do what we can to get the documents together, but I'm worried about something as interpretive as diligence being in a regulation. It sounds like an avenue for someone to say it wasn't enough.
What if
we have at least two efforts, and that could be in the regs because that's really objective, and then we can be in discussion with the board about, this one, we recommend this one be closed, and the board says, well, can you do some more? We can do some more, but I don't think putting a diligence in the regulation or all efforts, that I think that moves us back over toward being like an advocate for the applicant too. And I think we're more in an administrative capacity than turning into their counsel to make zealous advocacy type obligations on, and it's what's more of an administrative function.
Yeah, I would also, thank you for that. I also want to point out under G3, an application that's deferred, that also speaks to the same matter. An application is kept open because the board has determined the applicant will need more time to provide supporting documentation. So what we do in that situation is if we had no response after the 2 attempts, that the board then has the option to just defer the application, knowing that the applicant needs more time. It's not closing the application, it's deferring it.
Yep. Okay. I'm going to call this the Dr.
And to address your concern, Professor Moyd, the language here is that the board may deem the application complete, not shall deem the application complete, which allows the flexibility to defer an application should we realize that we have not been able to track the applicant in in BOP custody.
Yeah, the only concern is without reminding the reader that the burden is not just on the individual to provide the documents, that OGC is also playing a role. It makes it seem like the individual, if they don't get those documents in, the application is going to be closed. And so I just thought that by putting in something that reminded folks that OGC is also playing a role in trying to get the documents so that the board can make an informed decision. It's not necessarily being an advocate for the individual, but the board should want to be in the position to make the best informed decision possible.
What if we did just less language that's not quite as strong, like despite reasonable efforts to obtain them or something like that?
I think that works also.
Okay, so the board may deem the application incomplete and close the application despite reasonable efforts to obtain.
I think I'm sorry. I think I might put it someplace different. Let's see.
Within 3 months, despite.
Yeah. What if we did after within 3 months after sending the letter requesting the additional information or documentation? Oh wait, OJC will send a second letter requesting the information. If the applicant fails to respond
to the second letter within 3 months, despite reasonable efforts.
I think it just raises the question of, right, the letters are the effort. So what if we put, in addition to these 2 letters, OGC will make reasonable efforts to contact the applicant to obtain the information.
Right, and I think that's the whole point, is that these 2 letters are the reasonable efforts. Because we would not be able to send these 2 notices without actually trying to obtain reaching the applicant.
Right, I think I'm comfortable in that we also have the ability to not close it, but to defer it based on a belief that there's more information coming. What we're trying to do here is to have a reasonable effort on the part of OGC, the reasonable effort being the 2 requests or the 2 notices to the applicant that they're still needing more information. And then from there, we can still defer it if we have a reasonable expectation that documentation is coming, it's just not there yet. Any other comments from the board on that? Emily, I see you thinking through this.
I think if I were to make a suggestion, I think it could go here where it's if OGC does not hear from the applicant within 3 months after sending the letter requesting additional information, despite reasonable efforts to reach the applicant, OGC will send a second letter. I think the reason why it's a little confusing is those two letters are OGC's efforts to reach the applicant to get that information. So it would be technically a third effort, and that would be a substantive change to the regulations. Which
Christina, I'd like to add one more point. I think the backdrop here is that we are all operating in good faith and doing our best to make sure that these notices are going, that the applications are reviewed promptly, that the board is looking to see if things are missing and getting things promptly and working with BOP. I'm not sure that putting it in this one particular place that will make reasonable efforts, sort of it then calls a contrast to the rest of the regs where we're not saying the board is going to make reasonable efforts to review something in 6 months. It's expected. It's our good faith, our due diligence is expected. And so it feels a little odd to me to sort of note in this one particular spot that we will do that.
It's a good point. It's also in the interest of the board to act that way because we do want to be able to assist applicants and reach them. We don't want to, when we report that all our applications have been closed because we've been unable to reach applicants. And I think that's something that would not look favorably to the board.
But this isn't speaking to the board's good faith and due diligence, right? This is speaking to OGC's due diligence, right?
But we are part of the board.
Are there any other comments?
Professor Moyd, any concerns there?
Well, I guess the only my only concern still is that it's not just the board waiting for information from the individual. It's the board, yes, reaching out to the individual to see what information they have and maintaining communication. But at the same time, at least as I understand it, it's the OGC making a separate effort to try to obtain documents necessary for completion of the application.
Right, and Professor Moyd, us obtaining records for the completion of the application, for instance, if an applicant does not sign a release, we can't get that information. Right. So we would do our best diligent effort to reach an applicant to get the proper signatures. And I understand if they're not there, we can only do so much. And it's ultimately the board's decision, not OGC's decision, right, to defer the application. If we say we've provided 2 notices and we haven't been able to reach the applicant, the wording is permissive. It's not mandatory. It says the board may deem the application complete and close the application, not that the board shall. So the board may also defer it, right? And say, let's give this applicant more time. And that is not an OGC decision. All final determinations are a board's decision. We are just the administrators. If you would think of us as a purely secretarial role. Does that address your concern, Professor Moyd?
I think it does. Yes, I guess it does.
Okay, thank you.
Thank you, Professor Moyd. Okay,
We can go back to the public members.
sure. Next on the list, we have Tonio Calhoun. Mr. Calhoun, any comments, questions, or concerns? Okay,
Yeah, Mr. Calhoun is muted, and
I can attempt to unmute him. Mr. Calhoun, do you have any questions or
Yes,
concerns?
yes, I do. Thank you. I don't, my mute, my video, none of it is working on here. I'm not sure why. But thank you for unmuting me.
Sure.
Yes, I do have a concern. My concern goes back to what someone mentioned about notifying the victims of when an individual is placing an application. I'm concerned that that will in some way hinder the individual who is placing the application, particularly if the victim wants to respond by either notifying the DOJ or even the president and sort of giving like a detailed narrative of what exactly it is that took place that happened to them, which might some way influence someone in the DOJ or the president to then kind of, I guess, negate that application, which almost essentially winds up providing like a victim impact statement, almost as if you're putting this individual back on trial. And so I fear that doing so will cause this individual's time in prison, whether it could be 20 years, 30 years, to to not be taken into consideration. Here I'm an outreach coordinator and a peer navigator here at the National Reentry Network for Returning Citizens. And I'm currently working with an individual as a peer navigator who spent 30 years in prison for a very egregious crime. And since he's been out in September, this individual has gotten employment, he's gotten housing, he's working on getting his learner's permit, he's getting mentorship to navigate the technology of today, which has changed vastly from when he was locked up 30 years ago. This individual has done more with his life and more positive things with his life in less than 6 months than I've seen people who've never been to prison have done in 2 years. And so it's people like that who I fear that, when you talk about notifying the victims, it seems more to me like this antiquated notion of and I just don't see why it's necessary. I mean, if we're going to do that, then each and every time someone is released from jail or prison, you might as well do a public notification, which is not only practical, but it's irrational. So I don't see why that's necessary.
thank you, Mr. Calhoun. I appreciate your statement there. I do believe that the regulation or the law, the enabling legislation and law does make mention of victims. Am I correct on that, Christina?
It actually does not, no.
It does not. Okay.
It is not required by the Clemency Act. That
Right.
was
And see, that's what I figured. Like, if you're not legally obligated to notify a victim, then that's completely unnecessary and is only going to do more harm to the individual that's trying to apply for clemency than do anyone any good. And then not only that, but you also risk, I guess, re-traumatizing the victim, especially if this is something that happened to them 15, 20 years ago that they don't even want to relive. They're just suddenly getting this mailbox in their letter about something that they've been trying to put behind them. So you got to take that into consideration as well.
So I'd like any board comments, uh, any board members who are interested in addressing this issue.
Well, this is Andy Foyce. I'll just say I appreciate all of the concerns of the speaker, and I'm happy about the success of one of his charges. But I feel very strongly that victims need to be involved in this process. It's standard procedure for parole boards across the country. And I think we cannot turn a blind eye to the offense that the applicant committed and the effect that it had on the victim. And victims are not required to testify or provide any input. So if they want to avoid reliving the trauma, they're free to do so. But I think shutting them out of the process is the wrong way to go.
I would just also note, this is Emily, I do think it merits additional and deep discussion about the role that, or how and whether we will consider the testimony of victims or those otherwise affected by the underlying offense. I think the regulations are silent on it though, as I understand the current state. And so as we consider to think about the hearings and the criteria that the board will use in determining clemency, I think we can continue to engage with the public and engage in those sorts of discussions with the board.
I don't have much to add to other people's thoughts. I agree with you that we need to, I appreciate the comments, and I do think that there's a lot of factors that should be considered, not one factor to the exclusion of all others. But I do think that considering them in a totality, the person's rehabilitation, but also the offense that they're actually seeking clemency for, are all very important factors to consider, which the victim can provide insights to, in addition to any remaining dangers that some victims might face from the person applying. So I think that a holistic assessment is appropriate, kind of accounting for all of these different considerations, but recognizing that rehabilitation is an important part of that holistic assessment as well.
Thank you for that.
Is there a way to account for this by making the rehabilitation paramount within the consideration? Because that is sort of the crux of the inquiry.
And Katya, so rehabilitation is actually specifically required under the Clemency Act, so it is paramount already. I think the question is right now the regs are silent on whether or not victims are included in the hearing process, and that can be, as Emily indicated, fleshed out whether or not to engage a victim in this discussion should be something that we could discuss in our internal procedures and have a more robust conversation with the public about that.
And if I can just add to that, I believe that that's exactly why that should be taken into consideration, because in most prisons, especially in the BOP, if an individual wants to be rehabilitated, it's up to themselves to do that. They have to do that themselves. They cannot count on staff or anybody else. There is no rehabilitation going on in any kind of prison system whatsoever. So anybody that comes out of prison and is rehabilitated, they did that for themselves. They didn't rely on anybody else or any program or any class or anything like that. They wanted that. And I've known, like I say, I've known this individual and other individuals who have done that themselves. So I do believe that that definitely needs to be taken into consideration.
Yeah, thank you, Mr. Calhoun. What we're saying today is that is the primary rehabilitation is a primary view that we must take into consideration. So it is strongly considered. It is primary. Okay.
Can I make a comment to this particular point?
I'm not sure who's speaking.
It's Ms. Courtney Stewart.
Yeah,
the National Ranger.
Sorry. So, like we are in the 21st century. We thinking a lot of this, and so I think the victim point is has a lot of merit because it's a broad point. Actually, there's there could be many victims. You know what I mean? It could be many victims. Including the perpetrator himself. So, like, I believe I think there's a lot of discussion there, really, especially when we're talking about rethinking the criminal legal system, you know what I mean? So I would at least, keep, that on the table for, letting the public get involved in a discussion around that, because we've like I said, there's many victims, and why does the victim need to have a say so in the punishment part of someone who has went to prison when they already had an impact on the sentencing and the the proceedings itself. So, which is totally different. You know what I mean? The jail and the prison part of it, the victim is not there. The victim is doesn't get to see the individual on a daily basis, doesn't get to actually know what this person is doing on a daily basis. And so I don't see why in the times that we are in, that the victim, you know, is considered. Like I don't see where that weighs. That works with punishment, but it really doesn't work with rehabilitation. So I just want to.
Thank you for that. So I think we're kind of at the point where the victim conversation deserves more of a conversation. My concern is getting the regs. The regs do not preclude that conversation, and they don't preclude, they don't make a determination one way or the other about their conclusion. So I just want to pledge that I will recommend that this board, start to engage as soon as we're through the regulations process, that we start to engage around a public discussion related to victims and their proper role in this process. So I appreciate the public comments on that.
Yeah, thank you, Patrick. I appreciate that.
Sure. Christina, take us back to walking through. I'm a little concerned about time today, to be honest with you.
Sure. We just have one more person on the list, and that's Mr. Kelvin Blow. Mr. Blow, do you have a comment?
Yes. Good morning, everybody. My name is Kelvin Blow, Peer Navigator Coordinator with the National Reentry Network for Returning Citizens. I had two questions that I wrote down. One of them was pretty early on in your presentation. I was just trying to get a clear picture of the two separate processes of the DOJ pardon and the request for a letter of recommendation from the Clemency Board. I know you noted that the application doesn't have to be in for the DOJ pardon before you apply for a letter of recommendation. But I was wondering if both these applications were in simultaneously, and they both were to be processed with a decision on either supersede the other in regards to grant and clemency.
Sure. I'm happy to take that question, Patrick. Okay, so Mr. Blow, as a educational clarity standpoint, the Clemency Board does not have the authority to grant clemency, and that includes pardons or commutations. What we're providing is a letter of recommendation for an applicant. That goes to the President of the United States, and a copy of that would go to the DOJ Pardon Office for their notice that we're sending it to the President of the United States. There is no requirement that a DOJ application be submitted prior to submitting an application with us. If there is one simultaneously, we will look it up to see. The application asks an applicant, have you submitted a DOJ application? If they state no, then we won't look for it. If they state that they have, then we will send that to the DOJ, and it would go in and ask that it be supplemented in consideration for their DOJ application. An applicant can also send our letter of recommendation to the DOJ for consideration with their application in totality. The applicant is able to do that once they receive our letter of recommendation. The only way an individual can receive clemency for a district code offense right now, according to the law, is by the president. So we do not do that. All we're doing is a letter of recommendation. So there is no order needed that an application of the DOJ be conducted first. Our letter does not supersede the DOJ application or the president's decision. It's the president's decision ultimately that supersedes all of this. It is just a supporting documentation that the Clemency Board is recommending this person for a commutation or a pardon, and ultimately it's the president's decision, and he could reject or grant.
Okay, thank you for
And
that clarity.
Mr. Blau, one more piece of clarification. If for some reason the board decides not to grant a letter of recommendation, that has absolutely no bearing on the individual's ability to go to DOJ, put in an application for pardon or clemency and get it granted. So if the board decides not to grant a letter of application, it doesn't preclude the individual from seeking it.
Okay, thank you. And my second question is kind of like a two-part question. It was from 705.1B. I know we visited this earlier, but the 3 months for the closed application, I know you said that the board also has discretion to defer an application. So in these 3 months, it said that if the OGC doesn't hear back from the applicant after sending the second letter within 3 months, then they have the discretion to close the application. So we spoke earlier about diligence and efforts. And I heard someone mention something about tracking the applicant to make sure you send it to the right location. But I didn't see if that was a necessity or is there just an effort that's used on an individual discretion basis, because it's not that hard to look up and see where a person is to make sure you send a letter to the right spot on BOP inmate locator and punch in the first and last name if you know exactly who the individual is. So I didn't see that as part of like a requirement and the regulations to like be sure that you're sending. I know this, and it's kind of like a common sense thing, but when we were talking about it earlier, I didn't hear that specified as like a part of the process to be sure you're sending a letter to the right individual to the right institution. And that a lot of times is a reason why a lot of correspondences while incarcerated don't get responses, because you're assuming that they still at the same location that they started their sentencing. But people move and rotate throughout the BOP over the course of their years being incarcerated.
Thank you, Mr. Blow. I'm happy to take your question. So the retrieval process is not 3 months, it's 6 months. So we send after 3 months, the application is applied. We send a notice after 3 months, realizing that they need additional information. And then there's another second letter and then another 3 months. So in totality, it's 6 months. But what was ultimately discussed was that it says that the board may deem an application incomplete and close. So it's not permissible language. So if we realize that a person has moved and we want to be able to reach out to them again, the board will defer the application and keep it open until we're able to reach the applicant. And that was ultimately the decision, was that that permissive language will allow for that flexibility to institute a deferral to extend that 6-month timeline.
Okay, and that brings up the second part of my question. Are there specific elements that the board will curate to determine when the discretion is used to close the application versus defer it? Or is it just like on an individual basis? Because like you said, you may realize that a person has moved, or there may be other circumstances that I think should be outlined to use to make the determination rather than to close or to defer an application.
Right. And ultimately, we want to keep the language broad. And I'm happy to share my screen really quickly.
But I mean, this set of, I'm sorry, I didn't mean to cut you off. But this set of elements that I'm talking about can be like an internal tool used by the board. Like a guideline on how and when to make the determination on deferment or to close application.
Absolutely, and that's exactly what we mentioned earlier would be our internal process that we will flesh out more. We try to keep the regs a little bit more broader and not pin us down to these processes because things will change. Not every application is the same, and so not every application would need further finding of an inmate's location because some of them might not move. So I agree that that information will be fleshed out in greater detail in a board's internal procedures.
Thank you.
Sure.
Thank you very much. Are there any other comments or anyone else in the public we haven't heard from, Christina?
No, that is everyone.
Okay. And are there any other comments from the board at this point? I'd like to make a motion to the board to adopt the regulations as amended today. If these are adopted, the regulations will then be published in the DC Register. So, someone want to second that motion?
Second.
Motion.
So the motion has been made and seconded. All those in favor, please respond by saying aye.
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 Those opposed? Those opposed? Hearing none.
And I'll just note for the record that we're abstaining pursuant to our non-voting status.
Thank you very much. Duly noted. So with that, the regulations have been approved. Fantastic job. I just want to really say thank you to the OGC staff and the staff director. I think Christina has done yeoman's work to get this done, and I very much appreciate that tremendous effort to get it done. I also want to just say, you know, I'm thrilled. We had 83 public comments on these regulations. That's amazing, and it's awesome, and it really indicates to me the significance of this work for this community. And I just want to deeply thank all those who have stuck with us through this process and have brought those public comments forward. And I'm also proud that we were able to integrate so many of those public comments in the final project. So this has been a wonderful process from start to finish, and I very much appreciate that. So thank you, everyone. I do want to do our next item on the agenda was to review and vote on the application form for the Clemency Board. And I just want to do a quick time check with members of the board to ensure that we still are able to do that. Christina, would you have any anticipation of how much time it would take to go through the application?
It depends on public comments, but the application is about 10 pages long. And so it's about the same size as the regs were, but it's also spaced out. It's not as detailed. So it's certainly it's the board's decision based on availability to maintain a quorum or hold it another time.
And has the application been circulated? I have not had a chance to see it. So I would, I think it would be helpful to have a chance to review it before public discussion and a vote, even though we're not voting.
It has not been circulated. I was going to share my screen and comb through it, but you know, it's totally up to board members' preference. I'm happy to send it ahead of time.
I think it would be helpful, at least on my end, to have a chance to review it in advance of a meeting, and given other time constraints as well.
That's
think,
my
Mr.
request
Lisi,
for.
I think I'm gonna agree with Ilana on this one. Yeah, I need to see it ahead of time.
Yeah, I agree too. And Patrick, it's 11 o'clock. I'm going to have to drop off now. We've done a lot of good work in 2 hours, but my regular job beckons.
Understood. If I could just pull the board right now and see if there's availability. I know that we need 2 weeks notice to publish the next meeting. Is that correct, Christina? So the earliest that could be is, let's see, December 23rd. And I know that
Not do that day, all the schools are closed. And
yeah, we run into holiday at that point. December 30th would be the Thursday after that. I don't know that that's much better for most people's calendar. Could we look to have a board meeting on the application and on the letter to council adding the returning citizen seat to the Clemency Board on January 7th, Friday, January 7th? We did that at 10:30 on Friday, January 7th.
That's fine with me.
It's fine for PDS.
Works for me.
Fantastic. Let's plan on that, and we'll go ahead and do the public notice of all that. And with that, is there, just again, thank you. Huge effort, great meeting. Really got to the substantive stuff today. Very much appreciate that. Is there a motion to adjourn?
So moved, Patrick.
Second?
Second.
Second.
Okay, we're adjourned. Thank you, everyone.
Thank you.
Great
Thank
effort.
you,
Thank you.
Patrick,
Great work,
Christina, and
Christine.
everyone.